afternoon, everybody. I'd like to welcome you today to Health Translation Queensland, second session in our spring seminar series on intellectual property. Today, we have Sabine Sand, who's a Research Partnerships Manager at the UQ Faculty of Medicine, and Brigitte Asprey, who's from Research Contracts at Griffith, presenting for you. This will be an interactive session, so we'd really encourage you to put any questions to our presenters that you have using the chat function on your Zoom screen, or any comments that you have for follow-up. I'd like to hand you over now to Sabine and Brigitte to get this session underway.
Thanks for that, Helen. Before we start today, I'd like to start with an acknowledgement of country. Health Translation Queensland acknowledges the traditional owners and their custodians of the lands on which we meet. We pay our respects to their ancestors and their descendants who continue cultural and spiritual connections to country. We recognise their valuable contributions to Australian and global society. The Uluru Statement from the Heart in May 2017 was addressed to the Australian people and invited the nation to create a better future. We support a First Nations voice to Parliament enshrined in the Constitution. We will share in this historic legacy by voting yes in the referendum to be held later this year. For more information, you can see the UQ website on the screen or contact us afterwards. Thank you. And that brings us to the start of our presentation. I'll hand over to Brigitte.
Sorry, I'm Brigitte Asprey. I'm a Research Contracts Officer at Griffith University, where I've been working for the last 10 years, assisting with contracts for research projects. I have a Master of Law in Intellectual Property, and I'm a non-lawyer. I have a Bachelor of Biotechnology Innovation, so focused on commercialisation of biotechnology. And I gained an interest in intellectual property law and am very pleased to be here today to speak on it.
Thank you. Sorry, everyone, I was supposed to go first and I missed my cue. So as you know, I'm Sabine Sand, Research Partnerships Manager with the UQ Faculty of Medicine. I've been in this role for about 5 years now, and before that I was in-house legal counsel with UQ Research Legal, as it was known back then. I also have a Masters of IP, and in addition, I've completed some graduate subjects in health law. I've got a particular interest in focusing on new research areas and in particular clinical trials.
Thanks, Sabine. This one. Oh, spacebar. Thanks. Today, our session topic is on IP issues and examples. So I'd like to start by giving a bit of a recap of the last session. Sabine and I thought it was really important to continue to build on what has already been discussed. So the first session in the HTQ Spring Seminar Series was presented by Alex Stewart, who's a Senior Legal Counsel at QUT, and also by Dr. Karen Mongi, who's a Registered Patent and Trademark Attorney and the IP Manager for CSIRO. So they presented on tips and tricks regarding aspects of intellectual property, and they both discussed the importance of understanding IP positions at law for copyright, patents, trade secrets, and I remember them focusing on inventorship and authorship, and they also examined how those rights at law can be altered by entering into a contract. And for example, licensing arrangements or commercialisation arrangements or ownership of IP. Okay, so what we're going to explore further today is how the contract governs a project or activity. So we're going to what this means is that the contract is an instrument that the parties, who are generally the employers of the individuals who are involved in a project or the activity that's happening, they put in place to demonstrate their understanding of what is happening, who's involved, and what the rights and responsibilities of each of the parties involved are in relation to that specific project or activity. So in addition to thinking about what the position would be at common law without a contract, it's important to think about whether there are any related contracts or arrangements that already exist that relate to the activity that's happening that also need to be considered. Because as Alex mentioned in the previous session, a contract can change the positions that would be at common law. So it's important to check if your organisation has any existing contracts in place or policies in place that relate to the inputs of the new activity that's going to happen. For example, things like employment contracts, funding agreements related to the activity that's happening, and all of these things might dictate what's possible for IP in the contract that for the new activity. So what Sabine and I thought would be most effective would be to explore this through case studies, because we find it's easier to explain this with a bit of context. We want to both make clear that
Disclaimer.
We wrote these case studies. They're completely fictionalized, but
based on experience.
Yeah, there are things that pop up that we thought might be useful just to demonstrate the theme of our topic today. So after each case study, we'll be asking you for your thoughts about IP and contract issues relating to the study or the activity that's happening. So please use the chat to join in and let us know your thoughts, or if you have any questions.
Yeah, you can raise your hand as well. So before we begin, I'm just going to do a couple of refresher slides with some of the key IP concepts that we'll be looking at in case studies today, and the principles of which were presented in the last session. So first of all, there's copyright. So this is the protection of written works, so thoughts and ideas recorded in written form, and it also protects software such as the source code for apps and the look and feel of the apps themselves. Then next we have patent. So this is protection for inventions. So for example, devices or compounds. So some examples of products that have patent protection are vaccines such as Gardasil, or new medical devices such as a cochlear implant. Trademarks, it was another concept we looked at last time, and this is the protection of unique words, phrases, and logos, for example. So some examples of this include Apple for computers, and you can also get protection for colours such as the unique purple colour that Cadbury uses on chocolate bars. Outside of these main IP areas, there are various other areas of protection, so designs, plant varieties, circuit layouts, but we're not going to go into detail in those today because typically the aspects we see most in medical research projects are copyright and patent issues, and sometimes trademark issues. And then lastly, it's a bit controversial as to whether you call this a form of IP, but it's often treated like IP. So we're going to deal with it today, and that is confidential information. So that is information that may not be published or in the public domain. It might be an idea you have that's not yet recorded in written form, or it may be something that you've written yourself and never released to the public. And probably the most famous example of this is the secret recipe for Kentucky Fried Chicken. So sometimes companies find they prefer to keep something secret forever rather than give it formal protection and have it go into generic use after 20 years or whatever it is. And also just to make the point that sometimes you can have a bucket of IP protection for your project. So there'll be various elements of IP protection that will apply to your project. So for example, if you take a smartphone, so there are several forms of IP that protect elements of the phone. You've got the trade name of whoever made the phone. You've got its design, so its unique look and feel. You've got the software that it operates on. You've also got the look and feel of the software as you see it as the user, and you've got the written content itself. Okay, so now by way of refresher for the types of contracts we'll be looking at today. Sorry.
It's all right.
We've got a
We're
lot
having a
going on
technical
here,
issue.
being us.
Yeah.
We've got funding agreements. So examples of funding agreements, National Health and Medical Research Council, MRFF. We've also got the Cancer Council Australia type of funding agreement. Basically, any government entity that provides funding to, towards research projects, they will have a funding agreement of some kind. Next, we've got, sorry.
There we go.
Are you?
Yeah, I'm there. Sorry.
We've got industry agreements. So, for example, this is with pharmaceutical companies, or it may be, some other commercial entity, or it could be, a not-for-profit entity as well. And so industry agreements we're classifying as different from funding agreements because although they provide funding, they're not, they tend to have more of a commercial focus, and often they can involve commercialisation aspects to be aware of. Next, we have research agreements, so collaboration agreements such as the HTQ Research Passport Agreement, or any kind of collaboration agreement, governance agreements. You may also have material transfer agreements, confidentiality agreements. There's a number of them. And then also we've got employment agreements. So this is your employment agreement with you as an employed clinician with your hospital, or it may be an academic who's employed with the university. And then we also have student agreements. Now, students are not employees, except if they're employed by an HHS, I guess, but in the context of universities, student agreements are often dealt with to ensure that students will have access to IP data rights and IP data rights, confidential information for a research project, and they're typically on back-to-back terms with your collaboration agreement. So brings us to the first case study.
Remember, these are fictionalized.
Is there any chat yet? Any questions on any of the concepts?
No.
I'll just wait for quickly. If anyone does have any questions about IP or types of agreements, please pop it in the chat, but we'll just start with the first case study so we don't run out of time.
Okay. So Professor Samuel from Griffith University and Professor Fred from UQ are doing a research evaluation of a UniQuest-owned psychology program that motivates people to do daily exercise to improve their mood. The participants will be identified for the study by their GPs and referred to Professor Samuel for the information about the study and to provide their consent to participate in the study. Once consented, participants' involvement in the study is to undertake the psychology program by an app, which we're calling the intervention, and then to respond to surveys online at certain points throughout the intervention. So at the beginning, during, and after the intervention. Thanks. Survey data will be aggregated, analysed, and written up for academic publications and also for conference presentations. So this is something that we would often
this is
see.
quite a typical scenario. So we'll just give you a minute or so to have a think about that. And what we'd like you to do is pop in the chat any issues that you can identify based on your experience that might involve some of the, whether any of the types of contracts we've just talked about or any of the types of IP.
Yeah, well, I'd like you to try and think about when we introduced ourselves in the topic and thinking about with this information, when you're doing your work, you've got a project that you want to contract. What are the key issues that you would identify about this project?
Yeah, anything in the chat yet?
Nothing? Okay. Well, how about I give you an example? I've had a bit more time to think about this case study than everyone else today. But the key issues that I have identified in relation to this project are what are the inputs and what are the outputs? So particularly background IP are the inputs that are coming into the project, and the project IP will be the things that are created in performing the activity that the contractor will describe, and then commercialisation. Okay, so I identified the intervention app as background IP because it existed prior to the project.
I'm just trying to see if we can get the chat up.
Yeah.
There's none.
As I said, this app was owned by UniQuest, which is a third party to this arrangement. It's separate from University of Queensland and Griffith. So if I were working for UQ, I would be thinking, what kind of arrangements do we have in place with UniQuest around the intervention app?
Yes, thank you, anonymous attendee.
Thank
Come
you.
on, everybody. I know there's more of you out there, and I'm sure a lot of you have had experience in at least one research contract, particularly those of you in the governance offices or any clinician researchers. So please contribute, because it makes it a much more interesting session for everybody.
Yes, so that's a really good okay. We've got a comment that chat is disabled, so only Q&A works. Thank you, everyone, for sharing
Thank you, all
that.
those anonymous attendees. No, handshake doesn't work anymore.
Thank you for that. Yeah, so really good point about Griffith's input improvement to the intervention app. So a couple of ways that we could deal with that is if I was working for UQ, putting any restrictions on the use of IP, so potentially making clear via special condition that that it's to be used as is with no modification to prevent improvements. I did have a think about that. I'll pop up the
data from the app.
Yes, data from the app, which is the data from the surveys. And so, yes, and we have another comment that says, what about the psych program that is owned beside the app? And that's a good question. It depends on how you would protect it with the IP that Sabine was talking about earlier. So, there might be a trademark associated with the methods that go into the app. There's probably copyright if the intervention includes questions. The survey tool itself is likely to be designed during the project, so that would fall under project IP. And that would have copyright attached to it because it's something that's written, the questions and the way that they're asked. And then also something that would result from the performance of the activity or publication, so there'd be copyright in any articles or conference presentations that are prepared. And with regards to commercialisation, I had to think about this and thought it was unlikely to arise from this project, given that the nature of the project was a research evaluation of an app that exists, but it's still really important to think about in terms of
well, maybe future use in other projects.
Future use in other projects, yeah. And UQ, depending on what kind of arrangements it has in place with UniQuest or what arrangements it has with third parties who are also using the app for other uses, non-research evaluation purposes.
Yeah, in some cases too, you might have an app that's designed by a hospital team and in use in the hospital. And in those situations, commercialisation is less likely because the hospital team is going to want to keep it in-house for their use, for immediate use in patient healthcare outcomes. So they would own the copyright and any licensing rights in that. And they may have deals with other, say, hospital entities. But that's, a situation that's more about public use and use for good as opposed to royalties.
Yeah, but for this specific example, I mentioned that perhaps you could restrict use of the background IP so that any improvements to the app itself might remain with the owner, which I'm pretty sure the HTQ contract already does that. But should we move on?
Yeah.
Yeah. Okay. Thanks, Sue.
Okay. So case study number 2. So Dr. Lucy is employed at the Princess Alexandra Hospital and undertaking her PhD at UQ. Lucy's PhD supervisor is Professor Jane from the UQ Faculty of Medicine. Professor Jane is the lead investigator on a research project. Dr. Amanda from the PAH is a co-investigator on the project with Jane. Amanda and Jane have a current research project that they are undertaking at the PA. Amanda is collecting patient samples and data. Jane will be receiving de-identified data and samples from Amanda as set out in the patient consent form and SSA. Lucy wants to analyse the data and samples for her PhD studies. All parties intend to publish. Lucy's publication will be part of her thesis. Now, if we can just pop the Q&A back up and we'll just see what ideas people have.
And thanks everyone for the really great responses.
Yeah, we suddenly got this intense peppering. It was great. So
sounds like people know what they're doing.
Yeah.
Too.
Except for the person who put up about a handshake that's like 100 years ago now.
Exchange of letters.
Okay, well, actually, it probably still happens, but we recommend against it. Nothing yet. Come on, Jackie Robinson. I saw you put something in there before. I'm sure you've got something to add. Thank you, Adrian. That is an awesome response. Yes. Need to make it clear that patient data is going to UQ for the purposes of a student project. Yep, that is a great point to make. Yep. Ownership and restriction. Yeah, that's correct. So in the case of UQ, anyway, I can only talk to UQ. What we do is we have a student IP agreement, and that allows the students to publish their thesis. And it also allows them to access confidential information, which might be hospital or de-identified hospital data that's provided to UQ for the wider project. And then what we do is we enter into a separate student agreement.
Griffith does a similar thing as well.
Oh, okay. Yeah. I'm not sure if anyone from QUT is online or some other unis, you might be able to put some comments in. So yeah, student IP deed. Yep, that's all great. Just running through the chats. Research questions still needs to be addressed at an HHS level. Well, I guess UQ's leading the project, and so the HHS is a collaborator on the project, and what they're providing to the project, let's assume, is in-kind access to patients' facilities and de-identified patient data.
But that's a really good point in demonstrating that a lot of the time you need to have things in writing in a way that everyone understands them. So that's the purpose of why we get a contract in place to govern the project.
So just to the question about first authors on the publications, sorry, I don't have the details to hand today, but typically the publication guide is the lead and then the second authors, etc. And I'm not quite sure where the student fits into that, but you will have a local policy at your institution and you'll be able to check that. But there are quite a lot of published principles around authorship. Okay, Anna, thanks for the QUT position. That's great. Okay, yes. All right, this is a really good one too. So Lucy's employment agreement, given PAH facilities are being used. So in this situation, yes, Lucy is also a clinician, but she is undertaking her PhD at UQ. So typically the student IP agreement will take precedence under the governance agreement, and as Sonia has pointed out, the data or project IP will be owned by UQ.
Sonia's asked another question too down there. Can the samples data be used for future research purposes now that the samples data are owned by UQ?
So it just depends. It's quite a complicated question, and it would come down to the governance arrangements for the particular project. And then copyright owns thesis. Yeah, that's right.
It also depend on whether the data was project IP and if there's a license back.
Yeah, that's right. And if it's de-identified and then provided to UQ, it would just depend as well on what the patient consent form said. So I'm just going to run through and see if we've covered everything. So just in the scenario, check the enrolling institution IP policy for students. You may need a student IP agreement, or there may be other arrangements in place depending on your type of institution. You'd also need to check the hospital employer IP policy and the employment contract. So as has been noted, there's a potential issue there where you have a student who is also the employed clinician. We've got in terms of ownership of project IP, so the key IP elements are data, analysis and publication. And so in your governance agreement, then you would be looking at the ownership of IP as between the university, hospital employer and student, although the student wouldn't be a party to the governance agreement. However, there may be a separate governance agreement just for the student project. And yes, students will retain IP in their thesis. Okay, great one, everyone. Oh, sorry, there's just one Q&A from the last one. Ethics approval. Yes, that's correct. You would always need ethics approval. However, that's not part of our session today. We're just specifically looking at IP and contracts, but that's a great point. You would definitely need ethics approval for any human research conducted, and you would need it at a lead site. And then UQ or the other institutions would typically ratify that. Thank you.
There's one more question about copyright. Our understanding is that copyright's automatic. So
yeah, data is protected under copyright law. Alex did deal with that in the last session. Basically there's a series of rulings or cases called the telephone book directory cases. And in that it was deemed that once you have a collection of data or an aggregation, that is protected by copyright as an original work. Okay, sorry, we might just have to move on now to the next.
To keep to time, thanks.
Yeah.
Okay, case study 3. So Griffith has conducted a survey at Gold Coast Hospital and Health Service to better understand employee satisfaction levels. I've really picked difficult words. Gastroenterology clinicians.
That's cool.
So yay for me. The Griffith, CI means Chief Investigator, if you're not familiar with that language, has a conjoint appointment at Gold Coast Hospital and Health Service, which is Griffith's teaching hospital. The Griffith Chief Investigator discussed the study that he'd already completed with a colleague at UQ, and the two are now planning to work together to expand that study across more gastroenterology clinicians across Southeast Queensland. The study participants are clinicians at a number of hospitals. The study participants will be contacted by email through a professional organisation for gastroenterology clinicians. The email that they'll be sent will provide links to patient information and a consent form for their participation. And once those study participants are consented, they will be sent a link to an online survey with results to be stored securely at Griffith. So the results will be analysed and written up for academic publications and for conferences.
Okay, well, apart from the issue of having to say gastroenterology
3 times. Yeah, well done me. I wrote this, so it's my fault.
Yeah, so I can see something there, conjoint appointment flags a few issues for me.
Yeah.
Let's see, the Q&A is starting to go off again.
So can a research agreement contract?
The first one might be a little bit complicated. I would suggest you talk to your local contracts officer or governance officer about that.
Yeah.
Hi, Nicole. Thanks for attending. This is cool. Yes, background IP. Great point. Yep. Sonia, need to be careful as to which hat the conjoint is wearing when conducting the research. Absolutely. Yeah, we'll go into that in a bit more detail once we get on to the next slide. And GE to own all IP. Well, again, I guess that would just depend on the specific circumstances of the agreement and what was agreed between the parties. But yeah, it's important to realise that that's an issue to be considered. Yep, Jane, correct, dealt with the conjoint. Data sharing agreement, correct. And yeah, that's great. Conjoint appointment terms, yep. And Sylvia, I'm sorry, I would really like to know what your background is. Like, are you from a research background or a governance background? Because your questions are really specific. and interesting.
Yeah.
But
Both. Well done. Well done. you.
Okay, yeah, thank you. So probably just going into a bit more detail than what we can do just with this scenario, which is just really intended to just,
Highlight.
yeah,
when,
or spike
when
some
to
key
ask
points.
someone.
But yeah, thank you. Keep it coming.
Yeah.
Okay, so
Shall we
just
move on? Yeah. Okay. So
as identified.
Yeah.
Background IP is said. Oh, sorry, I just took over your section.
This is turning out really great that we can all really engage and chat with each other.
Yeah.
So yeah, the survey existed prior. So under this new arrangement, which will be governed by a contract likely between UQ and Griffith, the survey itself would be background IP that Griffith would introduce. There would be data from the previous study that might be ruled and aggregated into the new data set.
Yeah, and in particular, I would be sure if it hasn't been published, then you would want to protect it either as background IP or as confidential information, because that's, something that Griffith has created from another project. So you would want to make sure your agreement really carefully ring fences that one.
And we know that the HTQ
does that
template, has terms on confidentiality and background IP. So you just look at the definition.
Yeah.
Project IP, so data collected from surveys at the new sites. And you'd have to think about ownership between UQ and Griffith.
Yep.
So this was a really interesting example. And academic publications that are likely to result. So there is a third party interest with Gold Coast who isn't necessarily specifically involved in this second arrangement that would be between Griffith and University of Queensland. My understanding is a conjoint appointment is a contract between two organisations that one organisation is the employer of an individual and the other organisation through a contract shares the services of that same person and pays money to the...
Yeah, that's right. Both parties contribute.
Yeah, exactly.
Both parties pay the employment, the salary, as opposed to a secondment arrangement where one party would 100% pay the salary.
Yes.
Okay. That's great. Hang on, I'll just say.
But the really important thing, referring back to Sabine's earlier slide, is to check the contract to make sure that for the conjoint appointment, to make sure that there's not other IP arrangements.
Yeah, that's right. And you may have specific IP terms in that appointment. So what sort of evidence do you have to demonstrate when the work was done? Well, the best way you can do it is, for example, if you are working under your, let's just call it Griffith hat and UQ hat. If you're working under your Griffith hat, please send emails from your Griffith account and do your work on your Griffith laptop. And if you're working under your UQ hat, do your work and send your emails from your UQ account /UQ laptop. You can also keep logbooks and you may want to keep, your own time records, for example. And then Jackie has said, besides IP, to do... Jackie, I'm not sure. It looks like a couple of typos in that comment. I might get you to put that in again later, because I'm not quite sure what you mean by that. Thank you. Okay, so moving on. Oh, my turn. Sorry. Yes. Yeah. Would you like a bit of? So I'm going back to my first scenario, which involves Dr. Lucy and Professor Jane. So, so Lucy and Jane are conducting a new project at the PA and the Prince Charles Hospital now. Lucy is still doing her PhD. This project builds on the outcomes from the last research project, including patient samples and data collected for that project. Additional data and samples will be collected from Prince Charles for this project. Lucy and Jane are hoping that this project will generate some valuable IP. Lucy receives funding from the Prince Charles Hospital Foundation for her project. So I'll just open up the Q&A again. Anything jump out to you, Brigitte?
Adrian has asked a question.
Oh, Adrian, that is great. Yes, correct. You would need to check that your first project, so your patient consents and your HREC approval contemplated future research use outside of the former project. That's correct. Nicole, yes, that's a great point. So I guess I really wanted to highlight that the funding agreement from Prince Charles is going to be critical in this scenario as to its terms. Often foundation agreements will have terms around ownership of IP. For example, they'll want to own copyright in reports that you submit to them. And they will also want a share of commercialisation proceeds. And often that is non-negotiable for a lot of foundations. So particularly when you're looking at commercially valuable research, you are going to need to check the terms of your head funding to make sure that that aligns with what you want to achieve in the project, because sometimes it may not be the right funding for you, or you may need to restructure your project so that your IP isn't compromised. Sylvia, yes, that's a great point. Background protection, background IP is in the original work. That's right. So your governance agreement would then reference the former agreement and the IP created under that. And covered out as background IP.
Which also involves a student.
Yes,
so that's something really
I haven't even come up to the student point yet, but anyway, I've got it on the next slide. So valuable, in this context, valuable means commercial IP, but yes, obviously clinically valuable IP. If it's capable of IP protection, remember that's what we're talking about. We're not sort of talking about, philosophical concepts. What we're talking about is what is the IP protection regime, because that does then lead on to commercialisation of that IP as allowed under the IP laws. But it's a great point. Often research that is extremely valuable is not commercially valuable, but it's, in terms of its impact into healthcare outcomes is really important. So, yeah, correct. That's right. Talk to your commercialisation entity. And also for Queensland Health or HHS people online, that may be Hero. Is it? Or anyway, talk to your hospital legal department, or your local policies. Yeah, thanks everyone. Okay, so let's just check what everything we've covered off. Oh yes, okay, so now on the student issue, I was just going to say, please keep in mind that, like situations change over time or circumstances change over time. So you should always check your local policy, because policies can also change over time. And just to make sure that you're operating under the current scenario. And then also you would need to check any student IP agreement again. You might need a variation depending on the content of the former schedule of that agreement. So, for example, if the former student IP agreement was limited to one project, for your second project, you may need a deed of variation, but it just depends. Again, as I said, you have to talk to your enrolling institution for the specifics.
I think that's a really good point that we didn't. This is a really good way to demonstrate that projects get built upon and change. And the whole point, the theme of our session is to check what arrangements you already have. So you're going to, and then it's rechecking those same arrangements when the nature changes again. So it's a really good point, Sabine.
Okay, so background IP, you would have to check the terms of your last research agreement for new use in your project. And as someone pointed out, check your HTQ approval and last agreement for a new use for the proposed new use of the samples and data from your former project. In the project, in terms of project IP itself, the new agreement is going to need terms that allow for commercialisation. So, for example, in the HTQ Research Passport schedule, there are specific terms, or there's a section that you can fill in about the commercialisation aspects. For example, UniQuest may lead, or who's the Griffith entity? Sorry, Griffith Enterprise.
Griffith Enterprise.
Yeah, Griffith Enterprise may be named. You may at that point need to look at some kind of commercialisation, like a royalty sharing deed outside of your research governance agreement, depending on the sort of how critical the commercial value is. And then just with the funding agreement, so as I mentioned before, the terms may stipulate IP ownership and commercialisation requirements. So just be careful to check those, because you're going to have to flow those obligations from your governance or down to your governance agreement.
Yeah, I always like to think about when there's funding for a project, that generally the project wouldn't go ahead without the funding. So that's your North Star.
Yeah, that's right. Yeah. That's a really good way of putting it. And I also think of levels too. So I always think of, it's like, or, levels in a building, like your top level is the funding agreement, and that dictates how the whole project is conducted in terms of its general principles and what the funding is going towards. Then you'll have your collaboration agreement, and that could be a governance agreement. It might be a multi-institutional agreement if it's NHMRC funding. Looking at, how the funds are divvied up in a bit more detail about the scope of work. And then under that, say level 3, you have your service type arrangements or subcontracts. So for example, pathology service agreements, analysis, courier, might be MTA, might be clinical trial agreements.
Like fee for service and just
fee for service type arrangements.
Not collaborative.
Yeah. Okay, so I just went on to closing comments.
Yeah. So I think we've finished our case study. We might do a bit of a recap and then open up for questions again. Yeah. So our key takeaways from today are: check that when you are looking at a new project or activity that you want to contract for, check what is already in place in your organisation in terms of contracts relating to the inputs and outputs of the project, and check the policies related to the inputs and outputs. So the people, the who, what, when, where, why.
And how much.
Yeah. Remember that this contract is the way that it's the instrument that going back to the previous slide, trying to remember what I wrote, but the instrument that all the parties to the agreement use to demonstrate their understanding of what's happening and what the rights and the responsibilities of everyone are. And the other parties might have different requirements to your organisation, so you need to think practically and work together to come to a solution that everyone agrees to. And for questions about contracts and IP, if you're at a hospital and health service, speak to the research governance officer. And if you're at a research institution like a university, speak to your...
Everybody has a different job title, but basically talk to the person who does your contracts and for further advice, and they'll be able to help you from there. Yeah. So I just wanted to say too, that was a really good point before about working collaboratively, because all of us people, whatever you want to call us, nice words please, we will often pick up the phone and talk to each other and try and find a solution. If we're having a hard time, working out, how is the data being transferred, or who owns the IP, or issues about confidential information or project structure, we are constantly working together to try and make the sort of contract processes or execution processes smooth as possible, because we are acutely aware that just having your contract signed is only one part of your research project, and it is just sort of at the beginning, and having the right contract will just set you up for success throughout your entire project. So we're very conscious of that, and we always try and find the most practical solution to go forwards that still meets the requirements of our respective institutional policies. So always happy to have an open discussion with everyone about something that might be causing angst.
Yes. Yeah.
Okay, so now just a couple more questions in the chat.
Oh, back to Lucy and Jane.
Oh, sorry, Jackie. Well, yeah, I'm happy to go back to that scenario. So that's correct. So in the case where a student receives funding, yes, it would be administered typically by UQ, certainly at UQ anyway. There are some other HHS funding schemes, for example, CERTA, where it might be administered locally at the hospital, and then it could be, payments could be transferred to an institution or other party under an HTQ agreement or the governance agreement. What if they belong to the same uni? Oh, okay. So if the first project, if you had a different uni, so what, the student was bringing it? Yeah, I'm not sure, Jackie. Sorry, this might be getting a bit complicated for today's session, but happy to have a discussion offline. Yeah, okay.
That's a really interesting question.
Yeah, Indigenous knowledge. Yeah, again, each institution and HHS has their policies on traditional knowledge. So that's a very specific question, but it's great to be aware of it. And yeah, again, I would suggest talking to your RPM or contracts person.
So yeah, Griffith thinks about traditional knowledge in relation to, particularly when we have IP assignments in relation to projects, making sure that it's excluded from other forms of intellectual property, because there's a bit of a debate about.
Yeah, there is.
So we might steer clear of that for today, but it was a good question.
Yeah, and if you have it as a specific issue in one of your projects, Jackie, because you're at UQ, please talk to your RPM. Okay, so that looks like everything for today.
And we still have a bit of time. So if anyone has any questions about, thank you.
Thanks, Sylvia. I would really like to meet you in person sometime because you asked some great questions. So next time come in person, because we do actually have a whole auditorium with no one in it. Which is why we're so keen for the chat.
Oh, you're in Victoria.
Okay. Well, maybe you should come on a holiday.
We really enjoyed this as well. We really enjoyed putting it together, coming up with the case studies and thinking about how and why we do our work. And
why?
Sometimes that's the question, but it was a really good opportunity. And we had a quick chat this morning about being a non-lawyer with some
legal background. Yeah. And then I'm like a lawyer with some other background.
Yeah, you're working in a non-legal role.
Yeah.
We've had some people.
Had a real mix today, which has been really good of participants. So we hope you find it useful. Yeah. Oh, sorry, one more question. Type of contract. Yeah, that's a great question, actually. So what we do is we look at the facts and we go, okay, right. So in this scenario, and typically what I do is, first of all, I look at, do we have a head funding agreement? Because as I said, that dictates the scope of the project. So where you often have a funding agreement, maybe as opposed to an industry agreement, that might set up the flavour for the collaboration agreement. I also look at what the expectations are around IP ownership and in particular publishing.
Mm-hmm.
So where you would have, where you might have, an industry type relationship, you might just be looking for MTAs to source material or data transfer agreements from a partner. Or otherwise you'd be looking at a more collaborative relationship, in which case, you would use the HTQ schedule if it was someone who's a member of HTQ. Otherwise, there is a new, I always get it's a very long word, it's a multi-jurisdictional, multi-party, non-commercial trial CRA, which is like the Commonwealth equivalent now of a Medicines Australia clinical trial agreement. So where you have a clinical study that doesn't need a CTN, there is a new national template, and that's been out for about a year now. Yeah, it's
developed
quite
with
popular.
Hero and the other states.
Developed by Queensland Health. Sort of led by Queensland Health.
Yeah.
Based on the research passport agreement.
Okay. Yes. Yes.
Yeah. So HTQ played a role in that.
Yeah.
So the short answer is it depends on the facts. And if you go and talk to your research governance officer or your contracts person, they'll be able to guide you further, because every project has different circumstances. So it always depends.
Can I chime in there too with a non-legal response to that? But I always try to think about what is the key in the nature of the arrangement, like what is the primary thing in terms of risk and responsibility that we need to manage. So in terms of, like you said, a funding agreement, the project's unlikely to go ahead without that.
You're looking for publication otherwise.
But if that's not in place, then like, for example, if it really is a clinical trial, then I would be focusing on that aspect. So thinking about what's happening, who's involved, what the risks are, what the responsibilities are, and
flow
then
of money.
Exactly.
Where's the money going to?
Yeah.
That was a great question. Thanks for asking it. Okay, so I think we're done.
Yeah. Thanks everyone for joining in.
Yeah. Oh no, wait. There's one more.
One more.
Oh, thanks,
Thanks,
Anil.
Anil.
Oh, Anil, thank you. Anil works in HABS at our Faculty of Medicine. Always great to have you guys.
Thanks, everyone. Thanks.
Thank you.
Sonia.
Oh,
Thanks,
thanks, Sonia, for calling it intense. We actually love it. Like, this is our
It was
bread and butter.
really good.
Sorting out this stuff all the time is what we do. And that's why, like we were saying in the beginning, these are fiction. This is a fictionalized scenario, but it is actually based on things that we just deal with these questions day in, day out. And I think sometimes because the facts always change, it can be really challenging, but at the same time, it makes it so interesting. So personally, I love my job.
Yeah, me too. Yeah. And having an opportunity to talk about it with everyone, like, let's keep having the conversation because it will always be learning something new.
Yeah, agree. Yeah. And I guess thanks very much to HTQ for having us today. We're delighted to present and